Many of you who have been following this journey for quite some time, housing in the city of Kalamazoo, currently as it stands, is not equitable. And this is a necessary step to take it in that direction. And so just to give a brief overview, and I'll just give county, I'll give county numbers because I'm trying to paint a whole picture here. The city of Kalamazoo, or excuse me, the county of Kalamazoo is roughly 11% Black, yet 60% of the people that are in housing crisis are Black. And so when you peel back those layers and you look at that data, it all points at discrimination. It's not about socioeconomics. You have a lot of people who have the income who are living in hotels right now. And so inequitable housing destroys a community across the board, and it just disproportionately impacts some groups more than others. And so when you look at a climate of housing, and where the city in particular is trying to do a lot in terms of development and things like that, you have to ask yourself, if we create all of these units, will people be able to access them? And without these updates to our housing ordinance, we will not see that. And so other communities, as it's been lifted up, have already adopted these ordinances. Communities in the state of Michigan, communities across the country who have already seen that, you know, a lot of the reasons why our climate of housing looks the way it does is because of discriminatory housing practices, historically redlining and so on and so forth. And even though those practices are illegal, the effects are still the same. And so people have trouble. We have a millage program here that a lot of people voted on, Vote Yes for Kids. We have the housing choice vouchers. And with those, in spite of having those two programs, there are families every day that are not able to get into housing, because currently as it stands, you do not have to even consider a person just because they have a voucher. And so that leaves a disproportionate amount of families in a crisis situation. Same thing with evictions and with criminal backgrounds. We have many people who have, you know, their past, they have done things, whatever, and they're moving forward and they're living in hotels because they're not able to get into homes. We've got application fees. People are paying hundreds of dollars a week, not knowing if they've been approved or not. So all of these various factors that people have been going through for a very long time, this ordinance is looking to address them. Now, it doesn't fix everything. There are many things that still need to be addressed, but this is a step in the right direction to be followed by more.
Assessing the circumstances before you. A good example is, I'm not going to rent to anybody who has had a felony in the last 10 years. Well, there's a variety of types of felonies. 10 years is a long time. And so what we're asking you to do is, yes, if somebody had some type of felony of violence, maybe in the last 2 or 3 years, that might be important. But for somebody who had, for instance, driving away a motor vehicle, and it was 10 years ago, while it's a felony, it's not that serious, and you would not necessarily expect that person to be a rental risk in today. So that's what we're looking at, is that you make an individual assessment when you're looking at people's backgrounds and credentials.
Okay. Does this ordinance require housing providers and landlords to accept vouchers?
Would you like to take that question, Attorney Robinson? I could maybe start it.
I don't know that it requires, you just can't discriminate on the fact that the person is using a voucher.
Correct. It's more about the source of income is what is protected. And so if a potential renter can show you that their income can indeed pay the rent, it's about discrimination of the source of the income.
Well, and related to that, are we removing any income threshold requirements as a result of this ordinance?
No, we would not be. For example, the standard affordable income requirement being 30% of what your annual gross income is something that the state uses, the federal government uses. We would not be removing any of those standards.
And regarding the Civil Rights Board, what type of cases will they be hearing?
Well, they won't necessarily be hearing cases per se, because what will occur is if there's a alleged violation of our ordinance, and it appears that there is reason for further investigation after the complaint is initially reviewed, then it'll be investigated by an appropriate city department. It could be investigated by somebody from public safety. It could be investigated by somebody from community planning and economic development, or maybe even HR. People who have gotten within the city some experience in doing types of investigations, which we would call people in, ask them what happened, find out some other information, and then after that investigation is done, a report would be made. It would be submitted to the Civil Rights Board for its review, and so it can make a recommendation to the city managers to how the matter should be dealt with going forward, which could be arranged from a variety of things. It could be maybe a conciliation between the complainant and the landlord. It could mean prosecution. If this is not the first type of complaint that's been lodged against the landlord, we may look at prosecution. But if it is, if it's just maybe a question of communication, maybe that can be conciliated, and that there is no necessarily punitive action taken by the city other than trying to make everybody make the complainant whole.
Related to that, if there is a charge against a landlord and the city does begin an investigation, what type of due process rights does the landlord have?
They will have the usual due process that is available under the common law and the constitutional law. They'll have a right to have representation. They'll have a right to confront witnesses against them if we have a formal hearing. They'll have an opportunity to be informed of what the nature of the charges are, and hopefully they will cooperate with the investigation. If they don't, then the records can be subpoenaed. But yes, they will get the usual due process rights that are required under law.
And also related to that, will the court system have any involvement in applying or adjudicating cases related to this ordinance?
Only if there's a determination that the matter should be prosecuted as an ordinance violation, then that would go to the 8th District Court. Hopefully those would only be the extreme cases,